you've said in the past you're not on that path to impeachment. Are you still? How do you reconcile those?
Well, it's not off the table. You can't. I don't think you should impeach for political reasons, and I don't think you should not impeach for political reasons. It's not about politics. It's not about Democrats and Republicans. It's not about partisanship. It's about patriotism to our country. It's upholding the Constitution of the United States.
Impeachment is not off the table, but that isn't going far enough for New York Democrat Jerry Nadler. The House Judiciary Committee chairman has reportedly asked Pelosi to open a formal impeachment inquiry, but Pelosi's not budging, at least not yet. Speaking of Nadler's committee, the House just passed a resolution that would empower judiciary to go to court against Barr and Don McGahn over noncompliance with their requests for documents and testimony. Nadler's committee also just voting. Joining us now, former federal prosecutor Joseph Moreno. Joseph, first of all, with that ability to go to court to enforce the subpoenas on Barr and McGahn, what exactly does that mean? How effective is it? And what will the result be?
Hey, Andrew, it's good to be with you. So what this measure accomplishes basically is that it streamlines the process. So rather than the committees having to go through the entire House to vote on bringing civil litigation to enforce a congressional subpoena, the committees can do it directly. So basically it fast tracks their ability to go to court. But the structure is essentially the same. They have to go to court and they have to explain why a court should intervene and enforce a congressional subpoena by threat of contempt if necessary. So, and what both parties know in this fight, whether it be the House who is investigating and the White House or the recipients of these subpoenas, is that it takes a long time. Even though courts will ultimately enforce these subpoenas, it could take months or even years. So both parties know that there's a lot of value in negotiating. And so I think that while the House committees now have this fast-track ability, you're still going to see both parties really trying to negotiate the terms of these subpoenas, whether it be for documents or testimony, rather than run to the courts, because they know it's a long, drawn-out process.
Well, can Democrats, is there any way or any mechanism for them to get the courts to hear these cases quickly?
You can try. I mean, some courts have already fast-tracked some of these cases, knowing that these are really essential issues of the highest priority. That being said, there's appeals, and appeals take a long time. And there's ways that us lawyers can drag out litigation. We're very good at that, unfortunately, or fortunately, depending on how you see it. So in this case, even if courts are going to be willing to combine cases and fast-track cases, the fact is it's not going to happen tomorrow or next week or next month. All these things will take time.
If Attorney General Barr does get called or forced to testify, I think most people would have a sense of where that testimony would be likely to go. Plus, he might not get called now thanks to that deal with Nadler yesterday. But remind people why Democrats are so interested in hearing from Don McGahn.
Well, I think there's a notion that while the Mueller Report is very powerful, for those of us who have taken the time to read it, most Americans have not. It's a voluminous document. There's lots of pages. There's lots of legalese. And I think the idea is that by breaking it down through oral testimony, through pointed questions that congressmen can ask, that the American people would understand what's going on. It would resonate more, and there would be a sense of whether or not the public can really get behind an impeachment effort.
McGahn cooperated with the Mueller investigation without claiming any privilege during the process. We've heard that means he can't claim one now. I'm curious if that's true. And also, is the work of the White House counsel, which was McGahn's role, privileged? I always thought the White House counsel was not the president's attorney, so the attorney-client privilege didn't hold.
So you're right. It's less attorney-client privilege and more executive privilege. But in either case, the idea is that once you have waived privilege for one purpose, you can't then assert it later for the same information. So if you have waived executive privilege, or if you've waived attorney-client privilege, and you have had conversations or you have disclosed information, that privilege is broken, and therefore you can't a month or a year later say, well, hold on a minute, now I want to reassert that privilege. It's too late. So in the case of Don McGahn, it's likely going to be an uphill battle for him to try to assert privilege over materials that, or I should say the White House to assert privilege for materials or conversations or documents that have already been disclosed to the special counsel.
Joe, just about everyone, yourself included, that I've talked to says the White House has almost no case here, that in the end McGahn and Barr would have to testify. But after 2.5 years of Donald Trump, lots of people are conditioned to consider the worst case scenarios. What are the chances the administration takes this all the way to the Supreme Court, where Justices Gorsuch and Kavanaugh then cover the back of the guy who nominated them, and the Supreme Court sides with the White House?
I mean, that would be an unfortunate outcome because it would sort of add to the concern that many Americans already have that our courts are politicized. And it's always unfortunate to me as an attorney when I hear that people identify a judge as an Obama judge or a Trump judge or a Clinton judge. All our judges at every level, whether it be at state, federal, or the Supreme Court, should hear the facts and determine the law based on the law, not on who nominated them. But unfortunately, many Americans feel that politics always get involved. And so when you see things like that play out, perhaps, or potentially play out, it just feeds into the worst concerns people have about our judiciary.
So if a court finds for the Democrats and orders McGahn and maybe even Barr to testify, does that open the floodgate, or can the White House do this all again for somebody else, say Hope Hicks, who has also been subpoenaed to testify?
I think a lot of it depends on how quickly the Democrats decide who they want to testify and then how aggressively they pursue them. The sooner they start the process, the sooner that courts will ultimately make these decisions. So if they wait a year, and then they're going to find themselves most likely bumping up into the 2020 presidential election. So Democrats have to carve out a strategy. They have to figure out what evidence they want, what documents they want, what individuals they want to hear from, and then they have to move aggressively, and they have to be armed with good arguments. They have this stronger position, no doubt, but at the same time, courts will still want to hear from both sides. And they will not just automatically defer to Congress. They will want to hear from the White House why they think that either privilege applies or whatever other excuse the White House asserts, and that takes time, like I said. So unfortunately, it's not a fast process. Democrats are also going to have to figure out at some point whether or not this testimony is necessary. I mean, they have a lot of information from the Mueller investigation. They have a lot of the underlying evidence that we hear is now going to be produced by the Justice Department. So do they need to spend the next year having these fights over live testimony, or should they plow ahead with the information they have in the voluminous Mueller report that we waited 2 years for?
Let me take you back to yesterday's hearing in the House comparing Trump and Mueller's findings to Watergate. The star of that hearing was John Dean. The cable news network sort of broke away for breaking news, and the hearing itself wasn't exactly scintillating. Did an underwhelming performance yesterday, could that actually hurt the Democrats' cause, make it that much more difficult to get eyeballs if and when they do have something big coming?
I mean, that's I guess a political determination. As sort of a non-political analyst, I think I would simply say that whenever you have a witness from a legal perspective who's not really effective at broadcasting what you're trying to present, whether it's to a jury or a judge, you certainly could hurt your case. And perhaps calling John Dean as someone who has no firsthand knowledge of what's happened here. He simply is more of a historical figure. He can try to put some context as to what constitutes obstruction of justice and what was going on during the Nixon years and the Watergate affair. But perhaps he wasn't the wisest choice to start off with. And I think you would see a different audience if it was Special Counsel Mueller or Don McGahn or individuals that were directly involved or have direct knowledge of what we're talking about right now, which is, of course, Russia collusion or obstruction of justice.
Well, so let me put you in charge of the Democrats' prosecution here, because that's essentially what's going on in the Judiciary Committee. It's a prosecution just in a committee format. Who would that big witness, big name with access and insight be who can burst through the media bubble and actually get Fox viewers to pay attention? Who would you call?
I mean, I think that Robert Mueller would attract attention from both sides of the aisle, both political and the American public. I think that everyone would be fascinated to hear what he has to say. The problem with him is that he's already sort of laid out the fact that he's not going to go very far beyond the four corners of his report. So I think he is not going to be very apt to answer theoretical or hypothetical questions. He's basically said as much. So it could be a bit of dragging it out of him. But he would certainly be a very, very fascinating witness because he knows exactly all the information that he investigated over those 2 years. But even more importantly than him would be people that are actually involved in the underlying conduct. And if House Democrats want to effectively build a case, which is, you're exactly right. I mean, this is sort of a hybrid of a political procedure and a legal procedure. But if they want to be the prosecutors and build a case, they need to look at the documents and the wiretaps and speak to the people and elicit the testimony of the underlying conduct. That will form the evidence that ultimately will be or not be the basis for an impeachment effort.
Well, the first three names that pop into my mind are Donald Trump Jr., Paul Manafort, and Michael Flynn. Can you think of any legal rationale or that would prevent the House from calling them? I mean, they would certainly get the attention, and they were involved enough that they would know some of the details.
I mean, the House can effectively call whomever they want. And so it really depends on where they want to focus. I mean, if it's obstruction of justice, which seems like that's where the attention, then it would be on Volume 2 of the special counsel's report. It would be on the individuals involved with not so much the campaign, but post-campaign. How did individuals, including the president and those around him, react to the Mueller investigation? That seems like that's the crux. And that's probably the most appropriate area to focus on.
Well, like any good soap opera, the story continues tomorrow, and no doubt we'll have you back soon. Former federal prosecutor Joe Moreno, as always, thanks for the insight. Appreciate it.
Thanks, Andrew, for having me.
And up next, the House Judiciary Committee isn't just dealing with the Mueller report. It's also opened up an antitrust investigation into the biggest tech companies. And today, that committee held its first in a series of hearings. We've got the latest right after this.